Hi, welcome to Jus Cogens, the International Law Podcast. Today is a big day for this little platform of ours. I'm joined by a true superstar of international law, Professor Dapo Akande. Although he requires no introduction for anybody who tunes in to us, but I'll try anyway. He's a leading scholar and practitioner who is currently a professor of public international law at the University of Oxford. Professor Akande has taught in universities around the world, authored more than 60 publications on a wide range of international legal issues. He has advised many international organizations and national governments, in addition to working on litigations before international courts and tribunals, including the ICJ, ITLOS, and the ICC. On a more personal front, I'm indebted to Professor Akande for founding the famous blog of the European Journal of International Law, EJIL Talk, as it is a major source for a lot of our ideas and content on this podcast. And if this wasn't enough, Professor Akande is also the OG international podcaster, so to speak, starting EJIL Live at a time when the next best thing were lectures being disguised as podcasts. EJIL Live served as an inspiration for the launch of Jus Cogens itself back in 2018 when I was a graduate student at Leiden University. There's so much I want to pick Dr. Akande's brains on. However, this episode will feature a discussion on the United Nations International Law Commission, or the ILC, as we will refer to it henceforth, and what it's all about. It's a very special time to have this conversation right now with Professor Dapo Akane, as he has been co-nominated as a candidate for the upcoming election of the members of the ILC by 5 countries, including the UK, Japan, Kenya, Nigeria, and Slovenia. Without any further delay, Professor Dapo Akane, thank you so much for being on the podcast. It's an honor to have you.
Thank you so much, Omar. It's really a pleasure to be here, and congratulations to you on the excellent work that you've been doing on the podcast. It's been great to listen to or watch some of the previous episodes.
Thank you so much. So let's get right into it. Before delving into more substantive matters, I'd like to start by talking briefly about your journey from being a budding lawyer in Nigeria decades ago to being nominated to the International Law Commission by 5 states. How do you reflect on all of this?
I think the first thing to say is that I've been extremely lucky and fortunate at various points along the way. As you say, I'm originally from Nigeria. I did my first law degree in Nigeria. I then qualified as a lawyer in Nigeria before coming to England to do graduate work and then commencing my academic career here in the UK. One of the things that I think has been really important for me in my career is, the people that I've met along the way and people who served as inspirational mentors along the way. I was actually extremely fortunate when I first came to the UK. I sort of landed at the London School of Economics to do my master's, and I was taught there by 2 international lawyers. So then Professor Rosalind Higgins and then Mr. Daniel Bethlehem were my 2 teachers in international law. And they have ended up being sort of great mentors over the course of my career. I was really lucky that, Professor Higgins, as she then was in her penultimate year of teaching at the LSE. And she was then nominated to be a judge at the International Court of Justice. And so I got the opportunity to be taught by her just before she went to the ICJ. But one of the great things that happened to me, which, I count myself to be really sort of blessed and fortunate by, was that after I finished my LLM, both her and Daniel Bethlehem said, would you stick around for a year and sort of work for us, do some teaching and sort of work with us for a year? And, even though that was my first year of working, it was probably my best year of working. I was teaching at the LSE with them, undergraduate program, and also on the LLM, which I had only just finished myself, actually. And then I was working with them on cases that they were working on at the ICJ, and also working with them on their academic work. And that was just fantastic. I learned so much in that year. And, that was 1994, 95. So that's sort of 26 years ago, something like that. And, these are still people that I know well. And these are people who, 2 decades later, I was still sort of working with, so I and others co-authored Oppenheim's International Law in the United Nations with, by this time, Dame Rosalind Higgins, as she now is, more than 20 years later. So that's been fantastic for me. And as I say, really fortunate to sort of met these inspirational people. And in many ways, actually, I tried to model my own career and the way in which I work on the two of them.
So coming back to the topic of the discussion for this episode, the International Law Commission. So I want to understand a bit about the mandate of the International Law Commission in terms of its efforts for codifying and developing progressively international law. What do these terms actually mean, and how do these actions actually take place?
Yeah, so the mandate, as you say, of the ILC is the codification and the progressive development of international law. Now, the way that I sort of think about it is that the task of the ILC is really to try to articulate clearly what the rules of international law are in particular areas of the law. And I think that's a really important task, actually, because when we think about the function that international law serves, you say, look, what's international law for? What does it do? And one of the things that I would say that international law at least tries to do is to provide predictability, stability, certainty in international affairs. And it can only do that, actually, if the rules of international law are clear and if they're clearly articulated. And that's, I think, what the basic task of the ILC is, to try to articulate clearly what the rules of international law are, so that it's easy for states and other actors to rely on them in a predictable way. Okay, so that's the kind of general picture. But what does it actually mean, codification, and what does it actually mean, progressive development? I mean, in technical terms, one might say codification is just articulating the rules that already exist and sort of putting them down in written form. Whereas one might say progressive development is, as the word progressive or the words progressive and development indicate, one might say progressive development indicates, in some senses, changes in the rules. So, developing them in a progressive manner, whatever that might mean. So at one level, you might say one is about just capturing the rules as they exist, whereas the other is about thinking about how the rules might be developed for the better. The real question is, can you really draw this line between the two? I think that's where the complicated issue.
Right. So what I wonder is that whether the ILC plays some sort of a role in actually creating such rules as well.
Yeah, so I mean, that's the question. So you might say, look, progressive development is about creating rules, you might say, in theory, whereas codification is simply about capturing and sort of reflecting what the existing rules are. Now, there's been a long debate about whether the ILC should be saying this rule or this topic is codification, this rule or this topic is progressive development. And the ILC almost never does that. They don't say, that we're making this distinction. And you can think of the reasons why they don't make that distinction. One reason why they don't do that is, once you say that something is progressive development, then you're immediately signaling that this isn't the law already. And that in and of itself actually might mean that it never becomes the law, because everybody keeps saying, oh, but even the ILC said it wasn't the law. Now, my own view actually is that is similar to what the ILC has been doing, that it's very difficult to draw this line in all cases, in many cases, in fact. So even where you have clearly established rules, which you are trying to capture, there will be a lot of cases where those rules have sort of gaps that you need to fill in, where they don't totally cover the picture. And when you are codifying, you will need to sort of express something about those rules to cover those gaps. And there'll be a kind of blend or a mix between codification and development. Now, let's take, to make it more concrete, take the work of the ILC on things that we now regard as codification. The Vienna Convention on the Law of Treaties, the Vienna Convention on Diplomatic Relations, right? So these were projects where clearly there were existing rules, and much of those two instruments are thought of as codifications of law. But, even in some of the most fundamental aspects, when the ILC kind of articulates those rules, it is, once you put them in words, you are actually reflecting something which may not necessarily actually sort of capture everything that the practice. You have to systematize it. You have to express it in words. And that then sets a stamp on it, which might have been a little bit different if it had been expressed in a different way. So even take the basic rules on treaty interpretation, Article 31 of the Vienna Convention on the Law of Treaties. Everybody today, every international tribunal today refers to Article 31 as the rule of customary international law. But the ILC had to express that rule. They had to, in expressing that rule, they had choices to make about how they were going to frame the different elements of treaty interpretation. I think you had a podcast actually on treaty interpretation, now that I recall, on recently.
Yeah.
They had to express the relationship between the different elements that go into treaty interpretation. Now, I'm not saying this is radically different from what the position was before, but in expressing it, the ILC puts a certain stamp, and that stamp has now become the authoritative stamp on what the law is. So drawing that line is sometimes very difficult to do.
All right, great. That was really insightful. I want to understand in a more broader context how the ILC functions and carries out its work in terms of different activities that we've all read about and heard about. Debating text, they're having plenaries, preparing drafts, adopting reports. There's the function with which the special rapporteur performs. So how does it all really work?
Okay, yeah. I mean, it's a good question. I answer that question, of course, as an outsider. I'm not a member of the ILC. And so I'm also kind of looking in and just going on the basis of things that we all sort of read. So the first thing, of course, is that the ILC selects a number of topics to work on. And typically there will be 7, 8 or thereabouts topics that the ILC is working on at any one time. Once the ILC selects a topic, there will usually be, that topic is most commonly assigned to a special rapporteur to lead the work of the ILC. In other words, preparing reports for consideration by the ILC. Sometimes, though, topics are assigned not to a special rapporteur, but they're assigned to a working group. It depends on what the ILC wants to do with that topic. So the special rapporteur will prepare reports, and very often they will prepare drafts of the instrument that the ILC is going to adopt. They're sometimes called draft articles, they're sometimes called draft conclusions. And then the commission as a whole will reflect on the work of the special rapporteur. The debates are usually very detailed. You can read them, sometimes you can even hear them on the website of the UN. You can listen to them sometimes. You can certainly read the debates. And then once they've kind of come to some sort of view in their plenary sessions, the commission as a whole, the work is then referred to a drafting committee for that particular topic. And the drafting committee is the one that's then tasked with really ironing out and sort of honing in on the text that the ILC wants to adopt, the detailed language of what they want to do. So a text comes out of the drafting committee to the plenary has to adopt that. And usually this is adopted in two phases. So the ILC will usually, first of all, adopt a text on first reading, which is a sort of provisional draft. And then at that stage, the entire text is sent off to states to consider. The ILC says, this is what we think, this is what we're thinking of doing. And then states get an opportunity to comment. And then it comes back to the ILC, and they'll go through a similar process with the aim of adopting it on second reading, which is usually the final reading. Now, it's not just the text of the instrument that the ILC adopts. There will also be commentaries, which I think most of your listeners will be familiar with. The commentaries trying to explain the text, provide more information. And again, that's adopted by the Commission as a whole, providing sort of a stamp on that.
Right. No, that really makes a lot of sense, and it clarifies a lot of things for our audience, who are wondering how the ILC actually works. So there's something that you are not an outsider to, which is the election process. So I like to understand, how does the election of the members of the ILC happen? And given that you have been going through that process, what's that like?
Yeah, so the ILC is made up of 34 members from all around the world, and each sort of regional grouping within the UN is assigned a certain number of members. So there are 5 regional groupings, Western European, another group, Eastern Europe, Africa, Asia, what's called GRULAC, which is basically the Americas in the main. So a number of seats for each of those regional groupings. Members of the ILC are nominated by states for election, and that election takes place in the General Assembly. Every member of the UN gets a vote. So, you're sort of nominated, and then you're obviously hoping that states will vote for you. The nomination process for this particular election closed in June. The elections will take place next month in November. And typically, actually, people are nominated sort of well in advance, a year in advance, sometimes 2 years even. And I suppose the process is very simply, most candidates are having meetings with states, discussing the kinds of things that you and I are talking about now. States want to sort of meet you. They want to know a bit more about you. They want to know sort of what your views are, and they want to see whether they think you'll be a good candidate. So, it's probably a bit more involved than I had imagined it would be when
sure.
I was nominated, because there's a lot that you do in terms of talking to states. But I have to say I enjoy that. Talking to states about international law is fun.
Yeah, that's interesting, because you have had a vast career, spanning decades, contributing, researching, and teaching international law. So I'm wondering if this was probably a novel experience of sorts, and how did you go about it? Because I'm guessing you must not have done something of this nature before.
No, I've not done anything like this before. I've not run for anything in my life. Not class representative in school,
okay.
Not school council, nothing. I haven't, I've not been a candidate for anything ever. So that's novel for me. And I think there are sort of different ways in which I have sort of looked at it. I think if one looks at it as a sort of election process, which it is, then that's one thing. But the way that I like to look at it is to put the sort of positive spin on it for me, which is to say I really do enjoy actually having these interactions with states, find out what they care about in international law, find out how they think, the ILC is doing, find out what issues they are sort of considering. So that is good aspect for me. I've done a few things in the world of the UN before, so that's not entirely unfamiliar to me, but an election process is entirely unfamiliar to me.
So was it challenging in any way?
I don't know that I would say it's challenging. It takes time, which is fine, but I don't know that I would say it's challenging. It's there are 190 something, is it 193 members of the UN? I think that's right, something like that. You try to talk to as many states as you can, and then you realize actually 193 is a lot of states.
Sounds exhausting.
Yeah, and sometimes you have multiple conversations with them. But as I say, if it's about talking to states about international law, I like that. I actually do enjoy that.
I'm sure. All right, I'll come back to this and your vision and how you're going about this election and how you see the work of the ILC going forward from a more personal level. But there are a few issues that the ILC has been addressing recently and issues that it has perhaps not been working on. So I like to have your thoughts on a couple of them. I'll start from the recent and ongoing work on crimes against humanity by the ILC, specifically in regards to the work on the draft articles on prevention and punishment of crime against humanity, and what sort of implications this may have on the future of international criminal justice. So how would you reflect on this?
Yeah, so these draft articles were adopted by the ILC a couple of years ago. So the work of the ILC on that topic is done, and now the topic has moved to the UN General Assembly, and particularly the Sixth Committee, the legal committee of the General Assembly, is now considering this topic. And some states are of the view, and in fact, the ILC itself was of the view that this instrument should be adopted as a treaty. So the Sixth Committee will be, in fact, this year, there have been discussions and there will be discussions over the course of the next month or thereabouts as to how to make progress on adopting this as a treaty. Let me just, before I come back to this particular work on crimes against humanity, let me just say something about this process of how the work of the ILC sort of develops after the ILC has done its work. One might say that in the past, at one point, most instruments adopted by the ILC became treaties. They're the ones we've already mentioned: Vienna Convention on the Law of Treaties, Vienna Convention on Diplomatic Relations, the Statute of the International Criminal Court, and there are many, many others that we can think of that move from ILC product to treaty, usually via the process of a diplomatic conference where states actually get to then debate these issues to decide on what to do, or sometimes it's the General Assembly itself within actually the General Assembly that takes up the issue and then moves to adopt a treaty. That process hasn't happened so much in the last couple of decades. We haven't seen many ILC products become treaties in the last 20 years. If memory serves me right, I think the last ILC product that became a treaty was the work on the jurisdictional immunities of states and their properties. So the ILC produced articles on immunities of states. That was eventually adopted as a convention by states, I think back in 2004. So that's 17 years or thereabouts was sort of the last time. And the ILC itself has moved on to different types of products now, where sometimes the intention is not that it be a treaty. But to come back to the Crimes Against Humanity project, there the intention very much was that this would become a treaty, and it would be nice to see an ILC product actually once again be taken up by states, debated in either a diplomatic conference or in the General Assembly, and then states put their own stamp on it, and it becomes a convention. So it'd be nice to see that. And I myself personally hope that that will happen with this particular treaty. So on the substance of the Crimes Against Humanity project, what's the value of it? At a very general level, I think one might say, look, we have a treaty on genocide. We're all familiar with the Genocide Convention. We have treaties that set out and specify war crimes, the Geneva Conventions of 1949, the additional protocols of 1977 set out some war crimes. I think we all accept that crimes against humanity exist as a legal concept and that these are crimes. And of course, they've been prosecuted by various international criminal tribunals, the ad hoc ones and the ICC, but we don't have a treaty that spells them out in the same way as we do for genocide and war crimes. Now, you might say, but we've got the ICC statute. And that's true. The ICC statute does include crimes against humanity and does include a definition of crimes against humanity. The difference is, though, that, of course, the ICC statute codifies crimes against humanity for the purposes of the jurisdiction of that particular tribunal the International Criminal Court, and it's in a broader context of how that court works. Whereas this project is trying to do a number of things. One, define crimes against humanity, potentially, hopefully, for all states. And two, and this is something that's particularly important, it's not just providing a definition of crimes against humanity, it's also providing modalities for how states establish their jurisdiction, their own national jurisdiction for the prosecution of these crimes. So the grounds for jurisdiction for the prosecution of these crimes, providing rules in relation to investigation, rules in relation to kind of sort of mutual legal support by states. Also, importantly, actually, providing rules which, or spelling out, I think, rules which we all accept about the obligation of states also not to commit crimes against humanity, right? So for the ICC, it's about prosecution of individuals, and this project is about that too. But also states themselves have obligations in relation to crimes against humanity, which the ILC's draft articles tries to capture. So hopefully this year, we will see the beginnings of a process within the General Assembly for considering this product as potentially a convention that states will adopt.
Okay, so I like to pick on something, that you said that, since in the last 2 decades, a lot of the, ILC products haven't led to the formation of a treaty in the way that it used to happen, or it happened before. And you may choose not to respond to this because it might verge on the political domain. But why do you think that is? Is it because of geopolitics, or has it become very difficult to build consensus in international forums? On social media and in the academic, international, or Twitter circles, there are a lot of discussions that, if the Geneva Conventions, for example, were drafted or debated today, they would never receive the sort of ratification that they did, 70 years ago. So yeah, if you want, what sort of changes have led to this hesitation on the part of state parties to not build consensus, especially on grave issues like crimes against humanity?
Yeah, and I think it's a good question, and it's one that's really worth thinking about. I think there are a number of reasons for it. So one, I think, is, as you say, the geopolitical climate. Even the Crimes Against Humanity project that I've just been talking about now, not everybody thinks that we should have a Crimes Against Humanity treaty. So
yeah.
And there are issues there as to just the relations between states and how that kind of plays out in the treaty making process. So that's one reason. And I think we've seen generally, the last part of the 20th century, the very last decade, the kind of 1990s, probably a heyday for international law. The early part of the 21st century, the first decade, things as we started out, probably again, very hopeful. And then we've hit a bit of a stalemate, maybe the last sort of 15 years or thereabouts. So that's one factor. Another factor actually is unrelated to that. And I think another factor relates more to the types of topics that the ILC itself is working on, and actually the views of the ILC itself as to whether things should be treaties or not. So take one of the more famous instruments of the ILC, the articles on the responsibility of states with respect to internationally wrongful acts, the state responsibility articles. The ILC itself was very cool on whether that should be taken up as a treaty. Some states were keen, the ILC itself not so keen, because of the nature of that topic, the fact that this is really looking at the breadth of international legal relations. State responsibility covers everything to do. It's about the breach of every single international obligation and the consequences of the breaches of those obligations. And I think the ILC, certainly at the time, was concerned that it'd be very, very difficult to reach agreement by states, and that states would somehow unpick the work of the ILC. So another look at also some of the other topics that the ILC has been working on recently. Topics like the work on customary international law. It doesn't really seem to make sense to have a treaty on how customary international law is formed, or some of the topics that have followed on the law of treaties from the Vienna Convention, where it's more about clarifying some issues. So it's a combination of factors. It's factors outside of the ILC, and it's also the sorts of topics that the ILC has also been working on, which have led to this development.
Okay, that's really interesting. So the second thing that I want to talk about is something which we are very interested in, is Jus Cogens, and that's the name of the podcast as well. And the ILC has been working on Jus Cogens for some time now, and especially it came up with an illustrative list of a set of Jus Cogens or preemptory norms recently. I want to understand the value of perhaps creating such a list, exhaustive or not, and whether it is a worthwhile exercise and what contribution it can have to the entire discourse on Jus Cogens and on international law.
Yeah, certainly very interesting for you. On the Jus Cogens podcast, we should be talking about Jus Cogens.
Of course.
That goes without saying. Yeah, so you're right. The ILC has been working on this topic of Jus Cogens or peremptory norms of general international law for a few years. And the ILC adopted a set of draft articles on first reading. So a couple of years ago, sent that to states, and states are now making comments on that. And then the ILC will come back to trying to adopt a final and second reading version. I think their plan is next year, I think. So the first thing that I would say is that, yes, they do have this sort of indicative list of norms of Jus Cogens, but it's important to note that the ILC's project in this regard is mainly about, one, the methodology for identifying Jus Cogens norms, two, the consequences of saying that something is a norm of Jus Cogens. So those are the two main things that the ILC has been doing here. And then there was this big debate about, well, but shouldn't we also actually be saying that some norms are Jus Cogens? And there were some who took that view that the ILC should be actually saying that some norms are Jus Cogens, and that there were others who were saying, look, this will be too sort of time consuming, and that there are dangers here. Because, for example, are we going to be exhaustive? If we're not exhaustive, then there's a danger that if we don't identify certain things, that might be regarded as us saying that this isn't Jus Cogens. So on this issue of what are the specific rules of Jus Cogens, they've taken a middle path. So they're not working extensively on which norms are or are not norms of Jus Cogens. They just have this annex of an indicative list. And it includes things that I think we will all be sort of very familiar with: the prohibition of genocide, the prohibition of crimes against humanity, which we just talked about, the prohibition of aggression, slavery and racial discrimination, and other things as well. So your question, is this valuable, having this list? I can certainly understand why the ILC went down this middle path of saying, look, let's not try and spend too much time on thinking about which specific rules are rules of Jus Cogens, but without wanting to totally kind of ignore that. So what they've decided to do is to say, let's just identify the rules that the ILC itself has previously said are rules of Jus Cogens. So that's what is in that list, rules that the ILC itself has sort of previously said are rules of Jus Cogens. I think that was a good way to go, because it means they don't spend years trying to work out which is and which isn't, and they don't close the door on things. Having said that I think it's a useful thing to do. I think that there are also things that we need to be wary of. There are things that we need to think very carefully about. And this is about how those rules of Jus Cogens are formulated. What's the formulation? And it comes back actually to the point we were making earlier when we were discussing codification, progressive development. when you formulate something, actually you're putting your own stamp on it. And that is very important in how that rule subsequently develops. So in my view, there are two items on that list of the ILC where I think one has to be really careful as to how the ILC has actually formulated the peremptory norms of Jus Cogens, two relating to the use of force. And those rules are, I sort of have them here in front of me just so that I can remind myself of how they formulated them. So the prohibition of aggression is in fact the very first one they have in the list. And then the basic rules of international humanitarian law is another one they have in the list. And I think in relation to those two, the formulation is, I think, one can quibble with them, and I think is actually problematic. Now, the ILC itself recognizes this in their draft articles. They note that the ILC itself has formulated these rules in different ways in the past. So if you take the prohibition of aggression, the question, what does that mean? I don't think we sort of quibble with whether the prohibition of aggression is a norm of Jus Cogens or not. I certainly take the view that it is. But the question is, what does it mean? There are at least two ways of understanding this. One way is to say it's about the prohibition of particularly grave uses of force. Another way of understanding this is to say it's not about the gravity of the use of force that qualifies something as aggression. It's any non-consensual use of force which does not fall within the exceptions to the prohibition. So any use of force which is not by consent or which is not in self-defense or which is not authorized by the Security Council, that's aggression, whether or not it's particularly grave or not. Now, how you understand aggression actually as a norm of Jus Cogens is actually really important because it shapes how the law relating to the use of force develops. In fact, if I can put in a bit of a plug here, I and a co-author, we've just published an article in the European Journal of International Law talking about these issues of how the law relating to the use of force changes and the implications of the diversity of rules of the use of force for that change. So the fact that there's a norm of Jus Cogens here is important when we think about the change. But what the norm is critical, because if you think that the right norm of Jus Cogens is one that says any use of force which does not fall within the exceptions is violating a norm of Jus Cogens, then how you change the law and how you develop new exceptions, for example, for humanitarian intervention, then becomes a different matter, because then you're trying to change a Jus Cogens rule. So that's one. And just one last one. The basic rules of international humanitarian law. I have to say, I quibble with that formulation as a norm of Jus Cogens because it's not clear what that means. Are we simply talking about the rule that prohibits directing attacks against civilians? Or are we talking about a broader set of rules of international humanitarian law? And whether or not these are actually norms of Jus Cogens is contestable because there are a number of states that have long since taken the view that something known as belligerent reprisals is permissible with respect to some violations of IHL. And if that is the case, if that's correct, then I think it's impossible to say that these are rules of Jus Cogens. Anyway, long discussion. All I mean to say is, number one, I think it's valuable to have that list. Number two, as always, the devil is in the detail, and it's how you formulate these rules that becomes really, really important. And the fact that it's just in this annex, which doesn't tease out all of these issues, then becomes problematic because we don't get the richness of the debate on these issues.
Right. No, that's so fascinating. And now I'm regretting not doing this podcast on Jus Cogens instead. And I'm glad that you brought up that article, because that's what I was coming to next, although we are short on time. So I was watching your talk on that article by the American Society of International Law with a panel up against you. So this is something which I have always struggled with, and I'm obviously not a scholar, a very basic student of international law. In terms of how Jus Cogens norms are formed and identified, it seems like a very hazy, abstract sort of a process. At what point do the norms of custom reach that point where they transition into Jus Cogens norms?
Yeah, no, Omar, I think the first thing to say is, yes, I agree with you. There's a lack of clarity on exactly how that process occurs. Of course, we already in the Vienna Convention on the Law of Treaties had a definition of norms of Jus Cogens, peremptory norms of international law from which no derogation is permitted, is what the Vienna Convention says.
Yeah.
I actually love the way in which this is expressed, because first of all, we start from Latin, Jus Cogens. And then we try to define the Latin by use of a word peremptory. I don't know about you, but I don't think I ever used the word peremptory other than in the context of Jus Cogens. It's not something that I... So then we need to define, what do we mean by peremptory? It's not a word that I think in the English language is kind of in everyday usage. But the key is that point that the Vienna Convention already makes, norms from which no derogation is permitted. But importantly, it talks about norms which the international community of states as a whole accepts and recognizes as being sort of non-derogable. And the ILC's work in trying to clarify what that means, I think, is very helpful. So the draft conclusions on peremptory norms sort of digs a bit deeper into the methodology. So, for example, one of the things that's really useful in the ILC's work, which I think there's been a lot of debate on, is when it says the international community as a whole, well, does that mean every single state has to accept that these are norms from which no derogation is permitted, and that if even one state opposes that this is a Jus Cogens norm, that means it's not a Jus Cogens norm? The ILC's draft conclusions tells us it's a sort of vast majority of states. It doesn't have to be every single state. So that's helpful in sort of digging into the methodology. And, again, you're right that there is some lack of clarity, but, this is true even for the process by which customary international law forms. Maybe this is even slightly more clear because we have it's probably easier to understand now what the threshold of international community of, as a whole means than it is to understand what generally accepted means for customary international law, because we know that the threshold, at least for Jus Cogens, is really, really clear. And also, it has to be a rule that is recognized as one which can only be changed by another rule of Jus Cogens. So the work of the ILC here, I think, is very valuable on the methodology point. One of the things that work does is that it really does situate the process by which Jus Cogens is created within the context of positive international law. And I think, maybe we've also had debates on that for a while. It's actually going to be based on state practice, what states do and what they say. That's ultimately what's going to be determinative. At least that's what you get from the ILC's work here.
All right, perfect. So there's another thing which is more topical, I guess, in terms of everything which has been going on in Afghanistan recently. So one of the 14 topics selected for codification by the Commission in 1949 was the recognition of states and governments in international law. ILC has not submitted its final, report on the matter yet. Do you think that this is an area that the Commission should work on, or the General Assembly should recommend this to the Commission?
Yeah, so, thinking about what the rules are relating to statehood and thinking about what the rules are relating to sort of which authority is a government. It's one of the classic topics of international law, and one of the classic topics that the ILC has not yet worked on. I mean, I think the ILC could actually work on this topic. It's an issue that comes up all the time. Two issues, to be clear: statehood and then recognition. These are issues that come up all the time. The statehood issue, interestingly enough, is an aspect of one of the topics that's currently on the agenda of the ILC in an almost indirect way. Not indirect is not quite the right word, but it's an aspect of a topic. So it's the topic of sea level rise and international law, because one of the questions that arises in the context of sea level rise is what would happen if, for example, a state were to be entirely submerged. Would its statehood actually be maintained? So that is an issue about how, statehood is maintained, possibly lost, but how it's maintained. The question of how an entity becomes a state, the ILC hasn't worked on. And, I don't see any reason why the ILC couldn't work on this. Or the second topic, the one about which authority is a government. This again comes up all the time in international, and at the moment, actually at the General Assembly, it's not just Afghanistan that's an issue, it's also Myanmar. Which entity is the government of Myanmar is, and also an issue that the Credentials Committee of the General Assembly is looking at. It's one of the few sort of classical topics that the ILC hasn't considered, and why not?
Right, great. So moving to your own vision for the ILC and how you see its work going forward. So I like to quote something from UK's nomination brochure for your candidacy, in which you speak of an interest in developing the legal principles and institutions which support international cooperation, helping resolve international disputes, and ultimately promote the well-being of the individual. In the capacity of being as a potential member of the ILC, how do you conceptualize the alignment of this vision with the scope of the work of the ILC?
Yeah, so the point I think that I was trying to make there is that the work of the ILC specifically, but also international law more generally, is serving different purposes. So one purpose that it's serving is to provide a regime and a framework within which international cooperation takes place. Cooperation between states, international organizations, and other actors. So to provide a framework for that to happen. And then secondly, working on things which have a direct bearing on the well-being of individuals and of people. I actually don't think that there's, in theory, a distinction between these two things, because I think even those rules that are about providing a framework for international cooperation or at least should ultimately be for providing for the sort of well-being of the individual. But my point being that, you look at some of the topics of the ILC, they really are about how cooperation between states takes place. So, for example, you could think about the Vienna Convention on Diplomatic Relations, think about the work on the law of treaties, think about the work on state responsibility, or on the current agenda of the ILC, even the topic of immunities of officials from foreign criminal jurisdiction is about that. It's about how states are able to interact with one another in a way that promotes international cooperation. But at the same time, we also have some topics that are directly targeted at how we deal with the position of the individual. The crimes against humanity topic that we have been talking about is a good example of that. The topic the ILC worked on, the protection of persons in the event of natural disasters, is a good example of that. So some of them are more directly focused on the position of the individual. Some of them are kind of more about the framework within which state-to-state interaction takes place.
Okay. Are there any particular areas or issues of international law that you would like the Commission to address in the coming years, other than the ones that you have already talked about?
So my own kind of view of this is that I think, rather than individual members of the Commission or candidates for the Commission, everybody kind of coming up with their own topics, kind of pet topics, I think actually there needs to be a more sort of focused discussion actually between the ILC and states as to the topics that the ILC should be working on. So for that reason, I'm reluctant to say, oh, the ILC should do X or should do Y,
of course,
because I think there needs to be a deeper engagement actually with states as to what topics the ILC wants to cover. One of the reasons that I think this is important is what I said earlier, actually. The fact that, some topics of the ILC have not made that transition into being considered by states as topics for treaties. Maybe one way to actually improve that record is to have a discussion ex ante from the beginning between the Commission and states as to actually what topics states are particularly interested in. Having said that, there are a number of topics on, the ILC has something that's called the long-term program of work, where the ILC kind of puts topics on as potential candidates to move on to the ILC's current agenda. And I think that's the first place to look. What topics have already been identified as being sort of good topics, to have a good look at that list to see whether the time is ripe for some of those topics to move on to the ILC's current agenda. And so it's, there are a number of things there which I think are interesting: extraterritorial application of national law, universal jurisdiction, immunities of international organizations. These are all already there on the ILC's long-term program of work.
Okay, I won't hold you much longer. Final point. I know you have been more focused in terms of talking about what the ILC does and what it has been doing. But given that there's an election coming up, and you have been talking about your own work in the past, and how you see yourself contributing to the work of ILC. Is there anything you'd like to say on that front? Whatever it may be.
Make a pitch, you mean?
Yeah, we can call it that.
Okay. No, thank you. That's very kind of you. I mean, look, for me, it would obviously be a huge honor to be elected onto the ILC. One of the really interesting things about the ILC is that it's probably the only sort of body within the international law system that has a kind of general mandate, as we've been saying, for the codification and progressive development. What I mean by that is that there are many bodies that work on developing rules of international law in many areas, as there should be. International law develops in many, many different forms. Most of these bodies actually have quite a specific mandate to work on particular issues: human rights, law of the sea, trade law, whatever it might be, investment, treaty protection. Whereas the ILC actually has the opportunity to look across the field of international law to pick topics. And so being able to sort of work on that diversity of issues, that would be a huge honor. And for me, actually, one of the things that I have tried to do throughout my career is to be a generalist international lawyer, something that's, I think, increasingly challenging today. International law is so broad, so vast. Obviously, nobody sort of knows or works on everything in international law, but I try to be a sort of generalist. And there's an appeal, actually, for a generalist to be in a body that is also generalist in its kind of scope and mandate.
All right, perfect. Professor Dapo Akane, this has been an absolute pleasure coming into this podcast. I was a little intimidated, and I thought this would be, very difficult, but it was actually the easiest one that I've done so far. And that's, because of you. Yeah, it was great having you. And yeah, that's all from my end. I'll see you guys in the next episode. Thank you so much, Professor.
Thank you. It's been a pleasure. Thanks a lot.
All right.